Hello, welcome to EduSathi, your partner in education. In this video, I will be discussing the legal reasoning you require for the legal aptitude section of all the law entrance exams in India. And this video only deals with the introductory part of legal reasoning. Let's start. There are various law entrance exams which you can take to start your career in law in reputed colleges, but the most sought after law exam is Common Law Admission Test, which is conducted for 16 national law schools under CLAT. Other than CLAT, there are other important exams conducted like AILET, that is All India Law Entrance Test conducted by National Law University, Delhi. Other exams could be LSAT. It is conducted by Jindal Global Law School and SET, which is conducted by Symbiosis Law School. These are the exams which you can take to start your career in law. There are various essentials which you need to keep track of to build a strong base for securing well in all these exams. Like previous year's question papers of all these exams could help you to acquaint yourself with the pattern and the nature of questions being asked. Next thing you can do is to take mock tests, which will help you to have extensive practice and self-testing for time management and better accuracy. Lastly, you must start reading newspapers and magazines so that you have regular update on the legal arena, for example, related to the current affairs in the legal field. So you must start reading newspapers and magazine from now only. In CLAT, you get 50 out of 200 questions. 50 out of 200 questions on the legal aptitude section. This section is quite important because it's a tiebreaker section. Here you can see tiebreaker section. By tiebreaker section, I mean that you get a better ranking with the help of the scores you take in the legal aptitude section, because if there are various students on a similar score having total score of for example, you get a score of 50 marks and there are around 100 students on the same score, but you got more marks in legal aptitude section as compared to other 99 students, then you will have better ranking in total, because this section is used to break the tie between the students who have similar total score. So this section is automatically given more importance since it's a law entrance exam. So legal aptitude section is the most important section, which is used as a tiebreaker section. Last thing which you need to keep note of is that CLAT gives you a negative marking of 0.25 marks for every wrong question. So you must ensure that you are confident on the question which you are attempting, so that you don't get most of the questions wrong and negative marking as a result of the wrong questions. Next, we need to discuss is the type of questions asked in the law entrance exams. Broadly, there are two categories, that is legal reasoning and legal knowledge. In legal reasoning, you can get single principle questions, which means you will get a single principle and one or more questions based on that principle to be solved. For example, you get a principle on cheating, like we will discuss in further slides, and you get one or more questions or questions based on the similar principle. Next, you can get multiple principle questions. There could be two principles given, and based on those two principles, you might have to solve one question or multiple questions on base of that principles. Another could be cluster questions. There could be one principle given and 4 to 5 questions related to that principle, or it could be multiple principles and multiple questions given for solving legal reasoning section. In contrast with legal reasoning, legal knowledge is based on the static legal knowledge you have. Static legal knowledge would mean that there is no legal reasoning involved, and you have to have a pre-hand knowledge of certain principle and concepts or basic terminology related to law to solve this section. Legal knowledge section would also include current affairs, which means like you have a knowledge of recent popular judgments and name of the law minister or Chief Justice of India. These are the things which you can get in the current affairs related to legal knowledge. Lastly, it's a bit tricky section, that is you can be given questions without principles, and you would not be given the principle, and you will have to solve this question based on the knowledge you have. And if you have a knowledge that the particular principle could be used in the question, then you will be able to solve the question, because it requires pre-hand legal knowledge, and you will not be given any legal principle or law related to the question, as in you will not be given any hints that this principle would be applied on this question. So this section or the question based on this section would be a little tricky, but you get these questions rarely. Next we need to discuss is the topics covered in the legal aptitude section. Here are the topics given. For example, legal reasoning includes tort, contract, criminal law, constitutional law, international law, IPR, family, and general principles. These topics are written in the order of their importance. For example, we can say that torts, contract, and criminal law are the most important topics under legal reasoning. Most of the questions are based on these laws and concepts only. However, constitutional law, IPR, international law, family law, these are the less important, or we can say least important topics in the legal reasoning section. Under legal knowledge, which is based on the static knowledge, we already discussed that these are the three sectors which we can discuss. You need to have knowledge regarding basic concepts and legal terminology. You can get questions on the terminologies used in law. For example, you can get a question on who's plaintiff, who's defendant, and other legal principles or latent terms which are used in law. So you can have knowledge on those concepts and legal terminology, and you will be able to crack these questions. Next is current affairs. Like we already discussed, you can get questions on the recent recent judgments and questions on the legal field, like who's the law minister and Chief Justice of India and all that stuff related to the legal affairs. Constitution of India. By Constitution of India, under legal knowledge, we would mean the Indian polity related to the legal. For example, you can get questions on the emergency provisions or questions on how Supreme Court of India is dealt in the Constitution of India, what are the legal provisions, and such questions would be limited, but you have to have knowledge regarding Indian polity in the legal field to some extent to solve the questions based on the Constitution of India. Next we discuss the legal aptitude section, which was given in CLAT of 2014. The questions were easy, the level of difficulty was easy to moderate, and expected attempts out of 50 question was around 40 to 45, and you could easily score 33 to 35 score in the legal aptitude section of 2014. You can read out the summary that there were legal knowledge questions were absent from the paper, and basically the questions were based on legal principles from the areas of contract, torts, and constitutional law and criminal law also. There were no questions from the fringe subjects like intellectual property and international law. About 3 to 4 questions were asked from Hindu law, which is included in family law. And the questions was quite easy and direct. However, they were reported to be a bit lengthy and time consuming, sometimes which adds to the difficulty to the student depending upon his practice and his or her practice. So it's not that problem if you have practice to solve the questions. Trends in CLAT in 2013 and 12. The only difference between the CLAT of 2012 and 2013 was the number of questions asked from the legal knowledge section. As we already discussed, legal knowledge question can be solved if you have static legal knowledge, you have pre-hand knowledge related to law. In 2012, the CLAT had most of its questions from legal knowledge, which added to the difficulty of this this CLAT of 2012. However, in 2013, most of the questions were asked from legal reasoning part only, and they were the legal knowledge part was missing. The questions were lengthy and time consuming, but the level of difficulty was from easy to moderate. So these are the trends we've seen in 2012 and 13 in CLAT. Legal aptitude for AILET. Similarly, you can read out the summary. It's not that important to read out the summary. We can easily discuss that level of difficulty in AILET 2014 was also moderate, and out of total marks of 35, you could actually easily score 26 to 28 marks if you have had enough practice to solve the questions. Similarly, in SET, total marks of 30, and you could easily score 23 to 25 because the question were easy to moderate difficulty. Next we come out to the most important aspect of legal aptitude section, that is basic legal principles. These principles will equip you to have the adequate knowledge to solve most of the questions in legal section without having any other legal knowledge, without even reading out or studying other topics. These are the basic principles you have to have in mind every time you solve any legal aptitude section of any law entrance exam. The first principle as it read out is that every student must have the habit to read the principle very carefully. By saying that you should read the principle very carefully, I mean that every word used in the principle is important and relevant for the problem to be solved. Let's take the example. In these two principles, let's read the first principle. It says, when an injury is caused to a person by an event that could not be foreseen and avoided despite reasonable care on the part of the defendant, and the defense of inevitable accident can be used. Now let's read out the second principle. When an injury is caused to a person by a natural event that could not be foreseen and avoided despite reasonable care on the part of defendant, and the defense of inevitable accident can be used. By having the plain reading of this principle, you might think, if you do not read the principle carefully, that these principles are same. But there is a difference between these principles, that is the use of word natural event. This use of word natural event has changed the meaning of the principle drastically because there is involvement of natural sources. Natural sources involved in this accident. However, these natural sources are absent from the first principle. So somebody who is in the habit of reading principles rapidly and very fast, that person might miss out this word and might land up in a wrong answer. So you must read principle very, very carefully, and you have to take note of all the words used, because every word in law has its different meaning. A simple use of word shall in place of may will actually change the meaning of the principle, and you will end up in the wrong question if you miss out that meaning. So the first and foremost principle every student must keep in his or her mind is that the reading of principle very carefully and word to word. Next, we will learn the segregation technique. It says, second principle says that all the conditions mentioned in the principle need to be proved. For this, you can disintegrate the principle if needed, because it will add to your convenience and make sure that nothing is missed out in the principle. Let's take an example. This principle relates to cheating, which says, whoever by deceiving any person dishonestly induces the person so deceived to deliver any property to any person commits tort of cheating. Okay, so there are three ingredients in this principle. First is deception, causing someone to believe that something that is not true. If I make you believe that I'm not that I am knowledgeable enough to teach you, but I'm not. If you believe that, that would be deception. And next ingredient is inducement, to influence or persuade someone to do something, to, in this case, to deliver property, which is the third ingredient. And if a person by deception causes another person and induces that person to deliver certain property by making that person believe which is not what is not true, that would be the offense of cheating. So to add to your convenience, you must have develop the habit of disintegrating and segregating the principle, so that nothing is missed out in the principle, and you see the applicability and presence of all the ingredients of the principle, so that there must be deception, inducement and delivery of property. These three ingredients together would form the tort of cheating. If any of the ingredient is absent, that would not amount to the tort of cheating. Next principle says that you need not to go beyond the principle. Whatever is given to you in the paper at the place of principle, you must keep your knowledge limited and scope limited to that principle only. Any application of pre-hand knowledge of law or moral principles will land you in wrong answer. For example, principle says that anyone who publishes a statement that is likely to injure the reputation of another person is guilty of defamation. right? So there must be a publication of a statement which is likely to injure, that there is a belief that it will injure the reputation of other person. That publication would amount to the tort of defamation. So a normal student is expected to go by this principle. Let's take the fact. Anoop, a journalist, publishes an article accusing Namit Shah of encouraging the police to undertake the encounters. Later on, it was discovered that Namit Shah had rewarded certain policemen for encounters. Going by this principle, because there is nothing actual principle, I'll tell you that actual principle of defamation, actual law of defamation says that if anything, absolute truth is a defense. If you publish something which is true, even though it's injuring the reputation of another, that would not amount to defamation. But this principle does not give that part of it, because it does not provide it, the principle does not describe that if it's an absolute truth, then it would not amount to defamation. So in this case, Anoop would be held liable for the defamation. If somebody has a pre-hand knowledge that absolute truth is a defense to the tort of defamation, in that case, that person would read out the facts and give the answer that no, Anoop is not liable because it was a truth. Later on, it was discovered. But according to this principle, since this principle is only limited to the scope of the injury part of it without giving the exception to it, that is absolute truth, in that case, the answer would be that Anoop is liable for the defamation. So you must not apply your knowledge, your pre-hand knowledge or moral principles to the principle given in the question, so that you land up in the right answer, not the wrong answer, depending upon the scope of principle given. Next is, you must not fall for the emotional trap. While solving legal questions, there could be facts given which strike your emotional thinking. So in that case, you will not apply your emotions and you will not fall for the emotional trap. Let's take an example. The right of self-defense extends to causing death if one's life is in danger. That means if your life is in danger in certain circumstances, you could do something to defend yourself, that is self-defense, and you could actually cause death of the person by whose acts your life is in danger. So let's take the facts. Samba, a notorious dacoit, is being followed by Vijay, a police inspector, right, who has killed many criminals in past. He is famous for all those encounters. On being surrounded with cops and seeing that Vijay is aiming at him with a revolver and about to pull the trigger, Samba shoots Vijay in the chest, which comes to the bullet of injury. Vijay dies due to that hitting of bullet. So in this case, if you take your emotional thinking into it, you might say that Samba is a dacoit, so he does not have the right of self-defense because he is a criminal. He should not be hitting policemen with bullets, or he should not fire on the policemen. But according to law, every person, even though he is a criminal, has a right to self-defense, which comes under the right to life. So you must not fall for the emotional traps. In this case, Samba would be liable for the offense of murder, even because he can take the he will not be liable for the murder, because he can take the defense of self-defense in this case, because his life was in danger, because he knew Vijay is popular for killing criminals and he was aiming at him. So it was pretty clear to him that he might kill him. He will kill him actually. So in this case, Samba has the right to self-defense against the killing of Vijay. Last principle is, for solving the legal aptitude section, you must look out for the best answer. And not the ideal answer. Let's take the similar facts. In the case of self-defense, Samba is a notorious dacoit, followed by Vijay, a police inspector who has killed many criminals in the past. On being surrounded by the cops and seeing Vijay is aiming at him with his revolvers and about to pull the trigger, Samba shoots Vijay in the chest. Vijay succumbs to the bullet injury. Right? Answer. Let's see what could be the answer of this question. So you have to find the best answer which suits, fits in the principles and taking into consider the facts. First option is the right to self-defense cannot be available to a criminal. Somebody who falls for emotional trap would say that self-defense is not available to a criminal, but that is wrong. Next is Samba cannot claim right to self-defense since he was trying to escape police. That is also wrong. If he is trying to escape, then he cannot have right to self-defense, which is against the right to life of a person, even though he is a criminal. Samba could have shot Vijay elsewhere, hence he is guilty. This condition is, we cannot, whenever the use of term could and should have appears, it's clear that something has happened and now we cannot actually pass judgment on the basis of what could have been done, what should have been done. So that answer actually strikes out on its own. A could have option is not there because Vijay has already died. Now we have to decide whether he will be given the defense of self-defense or not. It's yes or no. We cannot pass a judgment on could have or should have. Lastly is Samba can claim the right of self-defense. This is the right answer as per the principle. It says that Samba has the right to can claim the right to self-defense even though he is a criminal. As per the principle, like we discussed, the right of self-defense extends to causing death if one's life is in danger. In this case, Samba's life was in danger. So while saving his life and having a right of self-defense, he killed Vijay. So he will be given the right of self-defense. Let's take some examples so that we can have that whether we have taken all the principles into account or not. First principle is, in the first problem, the principle is whoever by deceiving any person fraudulently or dishonestly, it's the principle of cheating we already discussed. Deception. First is deception, right? Fraudulently or dishonestly induces the person so deceived to do or omit to do anything which he could not do or omit to do. Here is inducement to do. If he were not so deceived is said to cheat. It says that somebody is induced to do something or not to do something. Omit to do something is not to do something. You were supposed to do some act, but you are deceived and induced not to do that thing which you could have done or not done if you were not cheated, if you were not deceived. In that case, it also amounts to cheating. If you are induced to do or not to do something which you could otherwise have not done, and you are doing it after inducement, this whole act is cheating. Let's take the facts. Nikhil is a proficient gambler who is used to make his living from his winnings. That means he's a gambler and he usually makes his livings from the winnings of the gambling he does. One day he met Ankit. There are two people involved. One is Nikhil, who is a gambler, and another is Ankit, and pretended that he was a businessman from another city who was novice at cards. He says that I am a businessman and I am a novice at cards, that I don't know how to play card. Novice means somebody who is new to playing certain games or is new to something, thereby inducing him to play a game of cards with him. So here is inducement. Ankit was very apprehensive about losing money and had told Nikhil that he did not wish to play with him if he was any good with cards. Ankit, he might have had little money, so he was apprehending that if I play with you, if you are a good player at cards, then I am not willing to play because I will lose my money and I am not willing to lose that money. Nikhil convinced him otherwise, that he was not a good player. No, he was not willing to play with a person who is a good player because he will lose his money. But Nikhil convinced him otherwise, that Nikhil is not a good player. So they started playing. After a while, Ankit had lost a large amount of money to Nikhil. When he comes to know that Nikhil's true skill at gambling, later on he complained that Nikhil had cheated him. So we have to decide whether Nikhil is guilty of cheating or not. Let's take the principles one by one. First was that you must read the principle very carefully. We did it. We have segregated the principles and we are not falling for any kind of emotional trap, right? And lastly, the fifth principle was that we have to look for the ideal answer amongst all these 4 options. Let's read out the options. First, Nikhil is guilty. Nikhil is guilty since he had fraudulently induced Ankit to gamble with him. This actually sounds very good option. Let's take other options also. Nikhil is guilty since he should not have taken advantage of Ankit's trusting nature. Here comes the word of use, should not have. Something has happened, but we are still discussing that it should not have been done, so this could not be the answer. Nikhil is guilty since Ankit should have taken a second opinion before. Nikhil is not guilty since Ankit should have taken second opinion before gambling. It might not be possible because Ankit was induced and persuaded that he was not a Nikhil was not a good player, so he could play with him. So he was not given any chance to. We cannot assume facts on our own, saying plainly. So this could not be an answer. Nikhil is not guilty since gambling contracts are illegal and the law will not protect Ankit if he was indulging in gambling. This also sounds a good option, but in this case we have to just decide. We do not have to go into the illegality of the case. We are just taking it as an example. So we have to decide whether he is guilty or not. If it was, it could be taken to the court. So this also could not be an option. The right option is that Nikhil is guilty since he had fraudulently induced. There was inducement, and he convinced him otherwise. So there was a fraudulent inducement, and he induced Ankit to gamble with him. So in this case, he is guilty for the offense of cheating. Right? So this is the right answer. Let's take another example. It's an example related to negligence. Negligence is complete where there is a duty to care. So first ingredient comes here, duty of care, and that duty is being breached, right? And same results in some damages. So the ingredients of this principle are: negligence would be complete when there was a duty of care on a particular person, and then that duty has been breached, and due to that breach of duty, it results in damages or some kind of loss. Let's take the facts. A surgeon operated upon B. Subsequent to the operation, B complained of a pain in his abdomen. On examination, it was discovered that A had left a mop in B's stomach. Right, such kind of breach of duty while operating. So in this case, there was a duty of care on A while operating, right? And that duty was breached while leaving the mop inside his stomach, and it has resulted in pain. And obviously there are further circumstances and further side effects of leaving that mop coming. So let's take the options and see what is the right example. Yes, A will be liable for negligence since there is a complete breach of duty of care. Yes, this could be an option. Let's take other options also. No, A will not be liable for negligence since it was an accident. No, there was a duty of care and he should have taken proper care while operating, and leaving a mop inside somebody's stomach cannot be an accident. So this is not an option. No, A will not be liable for negligence since no real damage was done. Yes, there was a damage to B, so this could not be an option. None of above will see. So A is right answer as per the facts and the principles combined together, that yes, A is liable for negligence because as a doctor, as a surgeon, he had a duty of care to take off, that he should have taken care while operating upon, but he breached that duty of care, so he is liable for negligence. Right? So this is the right answer. Lastly, at the end of the slide, at the end of this PPT, we will just discuss in brief that what we have discussed. These are things to remember. First thing you have to keep track of is that you have to read the principle very carefully. Every word has its own relevance in law. Second, all conditions in the legal principle must be proved to establish the crime or offense of or tort. Which could be done with the help of segregation technique. Keep your scope of understanding and application of law limited to the principles so provided, and applying moral principle or any other law may result in wrong answer that we discussed in third principle. Keep your emotions aside while solving legal section of the paper. That is, we should not fall for the emotional trap in the questions and the facts of the question. Look out for the best suitable answer, not the ideal one, which you think is the best suitable as per the principle given and the facts of the question. That answer should be chosen as the right answer, not the ideal one, which you think that in ideal situation it should have been done. So it should have been or could have been is to be avoided in all the circumstances. Lastly, do not assume, this is not a principle, but you must keep this in your mind, that you must not assume or extend the facts of the case on your own. You cannot imagine any facts beyond the facts given to solve the question. So these are the things to remember. I hope this video will help you to solve most of the questions, and these are the basic principles. So thank you so much for being with us. Thank you.